Up next, we are going to be hearing from 4 speakers in the Yukon community. They will be discussing the processes available to Yukoners who have experienced sexual harassment in the workplace. We will be hearing from Alexander Dezan, legal counsel from the Yukon Human Rights Commission, Kurt Diekman, President and CEO of the Yukon Workers' Compensation Health and Safety Board, Leo Lane, legal counsel from the Public Prosecution Service of Canada, and Michelle Rabeau, Supervisor from Victim Services. We wanted to bring together these 4 voices to clarify and solidify our understanding of their organization's respective mandates, jurisdictions, and definitions of workplace sexual harassment. We also want to further understand the possible outcomes of their respective processes. Of note, Victim Services brings accumulated experience in responding to people telling their stories of violence and harassment. Victim Services will touch on the supports available to people as they navigate their options. With this panel, we hope to move towards a community where members of the public know their options and make decisions with informed consent. Each panelist will speak about their organization for approximately 15 minutes. And at around 2 p.m., all the speakers will come together for a live discussion and Q&A. Without further delay, it is my pleasure to invite to the screen our first speaker, Alexander Dezan, legal counsel from the Yukon Human Rights Commission.
Thank you very much, Lisa. My name is Alexander Dezan, and I am legal counsel for the Yukon Human Rights Commission. I'm going to spend the next 15 minutes or so providing a high-level overview of how a human rights complaint travels through our process. So a critical function of the Yukon Human Rights Commission is the operation of our complaint system. The Commission has what's called a complaints-based process, which simply means that where an individual believes they have experienced discrimination or harassment, they are free to file a complaint with us. However, the Commission does not have a general mandate to monitor workplaces, service providers, or housing providers for any alleged violations. So although we're happy to take calls from members of the public and discuss an issue, provide any legal information that might be relevant for them, our process is only engaged when a complaint is filed with the Commission. So I'm going to outline the complaints process today, and I'll divide my time under the 5 main stages of our process. The first is the inquiries that we receive from the public. The second, I'll address the complaint filing stage and what it takes for a complaint to be accepted with the Commission. Third, I'll discuss the settlement of complaints. Fourth, I'll address the Commission's investigation phase. And finally, I'll discuss the Yukon Human Rights Panel of Adjudication, which is a separate body from the Commission that holds hearings to decide human rights complaints that happen to make it that far in the process. First is inquiries. So the first step of our process for nearly all individuals is inquiring with the Commission. This is simply the term that we use internally to refer to a member of the public contacting us with a question about a situation they're having. These are confidential, and the Commission is neutral at this stage. We cannot provide legal advice, but can provide legal information regarding someone's circumstances. So anyone is free to inquire with the Commission. So this includes people who feel that their rights have been violated, but it also includes businesses, employers, service providers, housing providers. If they have questions about human rights, our process, or a given situation, they are free to contact us as well. As a neutral party, we're there for both potential complainants and potential respondents alike, and we do our best to assist anyone who picks up the phone or swings by the office. The next step of our process is filing a complaint. We also refer to this as our screening process. So the Commission does not accept every complaint that is filed with us. In fact, approximately half of all complaints filed aren't accepted. In order for a complaint to be accepted, the Commission must satisfy itself of 3 things. The first one is that the complaint simply has to be filed on time. There's an 18-month limitation period outlined in our Act, which means that someone must file their complaint within 18 months of the unfavorable treatment that they have experienced. Second thing is that the Commission must have jurisdiction to deal with the complaint. All this means is that the issue in question must be something that the Commission is actually capable of dealing with. So although most businesses in Yukon fall within the Commission's jurisdiction, some workplaces and service providers are actually federally regulated, even though they may operate within the territory. So some common examples include First Nations governments, telecommunications companies, and banks. Human rights complaints against such entities actually have to be filed with the Canadian Human Rights Commission, as they fall outside of the Yukon Commission's jurisdiction. Finally, the complaint must describe events that, if accepted as true, could meet the test for prima facie discrimination. This was addressed earlier in the conference, but just as a reminder, this means that someone filing a complaint will need to tick the following 3 boxes. First, they must have a characteristic that is protected by the Act. Next, they must have experienced some form of unfavorable treatment. And finally, the unfavorable treatment that they experienced must have been based, at least in part, on the individual's protected characteristic. Something important to keep in mind at this stage of the process is that the complainant does not have to prove everything in their complaint, at least not at this stage. This means that they do not need to supply evidence to establish every fact or event in the complaint. This is the Commission's initial screening phase, and for the purposes of this screening exercise, the Commission simply accepts everything written in a complaint as true. However, evidence will come into play later in the process, and it's always good practice to keep all relevant documents and record relevant events in some fashion. Another important piece of information that is helpful to keep in mind about the Commission's complaint process is that it is a process of last resort. This means that individuals must exhaust any other processes or procedures that can address their issue before the Commission will be able to deal with their complaint. So the most common example we face with the Commission is where an individual is unionized and they have a grievance procedure available to them. So someone working through that process is still free to file a complaint with us. Anyone is free to file a complaint with the Commission at any time. However, the complaint may be paused to await the outcome of that process. This is one of the many reasons that we encourage people to reach out to the Commission to ask us questions first before filing a complaint, as we can discuss what alternative procedures might be available to them and if they need to be exhausted in their circumstances. The next thing I'll address is settlement of complaints. So once a complaint is accepted with the Commission, it is shared with the respondent. At this stage, the complaint remains confidential between the parties. That means the only people who know about the complaint are the person who made it, the person or organization that the complaint is filed against, and anyone that those individuals happen to have told. The Commission does not disclose any information about complaints to anyone. At this stage, the Commission is also neutral. This means that we do not take a side in the complaint, and we remain available to both complainants and respondents to answer questions and provide information, though not legal advice. Once a complaint is accepted and shared with the respondent, the Commission asks the respondent if they're interested in settlement. Settlement simply refers to the process by which a complainant and respondent agree that the complaint will end on certain conditions. This can include a number of conditions, such as the respondent providing some form of payment to the complainant, for example, certain accommodations being made, or the respondent undergoing human rights training or developing certain policies. The Commission's policy is to encourage parties to settle the complaint before referring it to the next stage of our process. However, complaints will only settle where both parties are interested in settlement. If the parties indicate a willingness to settle, the matter may proceed in a number of different ways. For example, the parties can exchange settlement offers in writing, which often travels through the Commission's legal counsel who assists the parties in coming to a settlement. Or at least before COVID, the parties could all get together in a room and discuss settlement, with the Commission's legal counsel acting as a mediator to facilitate settlement discussions. It should also be noted here that any discussion about settlement terms is confidential and remedial. Human rights processes are not punitive, but they are instead designed to return the aggrieved party to the position they would have been in if they had not experienced the discrimination or the harassment that they allege. Human rights damages, even if awarded later on at a hearing, are designed to serve this remedial purpose and are not designed to punish someone for wrongdoing. Now, even if the parties do not indicate a desire to settle, or even if the parties try to settle but just can't come to an agreement, that doesn't mean that they can't agree to settle down the road. In fact, parties can agree to settlement right up to the date of a hearing. And it should also be noted that the complainant is free to withdraw their complaint at any time. The next stage of our process is the investigation phase. So if the parties do not come to a settlement agreement, the next stage in the Commission's process is the investigation stage. This is where our process slows down a bit, as some investigations can be quite time-consuming to complete, and the Commission has a number of investigations to complete and can only do so many at a given time. So it's not uncommon for an investigation to take more than a year to get finished. A human rights investigation is also a form of screening performed by the Commission. At this stage, the investigator is tasked with asking one question. Is there a reasonable basis in the evidence that this matter should proceed to a hearing before the Yukon Human Rights Panel of Adjudicators? As previously mentioned, when a complaint is initially filed with the Commission, the complainant does not have to provide evidence to support their case at that time. However, when a complaint is referred to investigation, it's at this point that the Commission does become interested with the evidence that exists that might support the complainant's claim. An investigator is neutral, and their job is to gather evidence that might be relevant to the complaint. This will begin by asking the parties to provide any documents that they might have that could support their position. So this can include just about anything: emails, doctor's notes, payroll information, performance reviews, really anything that a party believes could be of assistance to the investigator. An investigator will also likely interview the complainant and the respondent, and quite possibly additional witnesses as well, to get more information regarding the events in question. So an investigator engages in this evidence gathering process to determine whether or not there is any evidence that exists that could support the complainant's case. They're not determining specific facts. They do not weigh evidence like a decision maker would at a hearing, and they do not assess credibility of witnesses. In short, they aren't a judge. They are simply gathering and reviewing all the evidence that is available to see if some of it could eventually support the complainant's case. After receiving the evidence and conducting all the necessary interviews, the investigator will draft a report. In preparing for this, they will review the evidence and any relevant case law. So case law means reported human rights decisions about similar issues with similar facts. Again, an investigator does not make a decision like a judge would in a court, but instead makes a recommendation based on the evidence and the case law that applies to the complainant's situation. Where there is at least some evidence that the complainant may be able to make out their case later on at a hearing, an investigator will recommend that the matter proceed to a hearing. Where no such evidence exists, the investigator will recommend that the matter be dismissed. However, the investigation phase does not end with the report. Ultimately, it is the members of the commission that decide what should happen with a complaint. Commission members are not employees of the commission, but are individuals appointed by the legislature for a 3-year term to make decisions regarding matters such as this. The investigator makes an investigation report with a recommendation for their review. Once a report is drafted, it's shared with the parties. They're offered time to review the report, provide submissions based on the report, and the commission members will consider those submissions and the report when deciding what to do. If a party disagrees with the report, they're free to state why in these submissions. If the commission members decide that the matter merits a hearing, they will refer the complaint to the Yukon Human Rights Panel of Adjudicators. If they do not, then the complaint would be dismissed and the complaint would be finished. The last section of our process that I'll address is a potential hearing before the Panel of Adjudicators. So all jurisdictions in Canada have some form of administrative body that's established to hear human rights complaints. That body in the Yukon is called the Yukon Human Rights Panel of Adjudicators, which is completely separate from the Human Rights Commission. Some jurisdictions, such as Ontario, have what's called a direct access human rights system. So this means that when someone has a human rights issue and they'd like to file a complaint, they actually file it directly with the tribunal. This process more closely resembles a typical court procedure. However, in the Yukon, where the commission is set up to screen, investigate, and help settle complaints, matters only proceed to a hearing when referred by the commission. So the vast majority of complaints are settled, dismissed, or withdrawn before reaching this stage. It's only a small minority of cases that eventually reach a hearing. It's only when a complaint makes it this far that the commission's role also changes. To this point, the commission's process is focused on gathering evidence, screening complaints, assisting the parties with settlement. The process is consistent, and it's based either on the Act, its accompanying regulations, and case law. Until this point, they're neutral. But at a hearing, the Commission stops being a neutral entity and actually is a separate party at a hearing. The Commission's lawyer is not the lawyer for the complainant or for the respondent, but instead takes positions that are in the public interest. In many cases, this will mean taking a position similar to that of the complainant. Another important thing that happens at this stage of the process is that the complaint is no longer confidential. Like courts, hearings before the panel of adjudicators are public. This means that media may attend or report on hearings. As such, the parties should expect that things will no longer be confidential following referral to the panel. It also isn't until this stage that evidence will have to be presented to a neutral decision maker for them to ultimately decide what happened and how the law applies to the situation. In short, it's only at this stage that someone will make a decision stating, yes, you have experienced discrimination or harassment, or no, the events in question did not rise to that legal standard. So all legal cases are highly fact-dependent, but human rights cases, including workplace sexual harassment cases, are especially so. What often matters most are the very small details of what was said or what was done. For example, 2 cases where a complainant alleges that they experienced a toxic work environment based on inappropriate sexual joking and commentary can have very different results. So did one experience inappropriate joking on a monthly basis versus a daily basis? Was some joking accompanied by inappropriate sexual imagery in one case and not the other? In one case, did the employee have to take medical leave as a result of the harassment? These types of facts, although often difficult for complainants to re-experience at a hearing, are central to whatever remedy they might be able to obtain at that hearing. I'd like to finish on this note to bring us back to where this all started, inquiring with the Commission. We've discussed reporting workplace sexual harassment throughout the day in various ways, which includes using the Talk to Spot software available through the Commission's website. This is a great tool for creating time-stamped records of incidents of workplace sexual harassment. However, regardless of how you choose to do so, it's always wise to document instances of workplace sexual harassment as they arise to keep your memory fresh and to keep track of what may be many separate instances of harassment. This is helpful not only in the initial reporting phase with the Commission, the inquiry, but also in drafting your complaint, in getting through an investigation, be it through our process or another investigative process, and if necessary, excuse me, a hearing. And as always, if you ever have any questions, you can always reach out to the Commission and we can book you an appointment to have an inquiry. Thanks very much.
Good afternoon. My name is Kurt Diekman. I'm the President CEO of the Yukon Workers' Compensation Health and Safety Board. And I'm really happy to be here today to talk to you about the new workplace violence and harassment regulations that are coming into effect this year. So first of all, just a little bit about the Yukon Workers' Compensation Health and Safety Board. One of our primary focuses is preventing disability. So what this means is working with workers and employers to prevent work-related injury. And where there is an unfortunate incident that does result in an injury, ensure appropriate medical treatment and wage replacement are provided to workers to support them in their recovery. Violence and harassment aren't new hazards for workplaces. OHS legislation has always had requirements to protect workers from all hazards. The Workplace Violence and Harassment Prevention Regulations were introduced to provide specific direction on how to protect workplaces from the harm of violence and harassment. These regulations contain the minimum requirements that are shown to prevent violence and harassment in the workplace. The regulations come into full force in September. Until then, we'll use the regulations and our guidance documents to help workplaces establish their policies and procedures for preventing workplace violence and harassment. Now, when we talk about minimum requirements, these are some of the things that we're talking about. So first and foremost, we looked at the definitions and defined things like hazard, violence, and harassment in the regulation. Now, the regulation also requires there to be written policies. Now, written policies have to be developed with workers in the workplaces, and typically that's done through joint health and safety committees and health and safety representatives. But if your workplace isn't required to have a joint health and safety committee or a health and safety rep, then working with the employees in the workplace is a great way to get that worker input. There is a requirement to have a statement that very clearly states that violence and harassment is prohibited in the workplace. You need to talk about how you'll eliminate or control hazards, and make sure that workers understand they have a right to bring complaints forward confidentially. There's also a requirement for written procedures. Same again, should be developed in conjunction with workers in the workplace. Need to have procedures on how to report incidents, what sort of post-incident care there will be for those that are affected by workplace violence and harassment, what to do when you receive a report, and what will happen during and after an investigation. There has to be some clarity around investigations. Who conducts the investigation? Who's responsible for the costs associated with those investigations? And there's also a section on domestic violence. And where you do have a disclosure from a worker that they may be a victim of domestic violence, in the workplace, you have to make sure that that worker is protected while in your workplace, and make sure that if there is the potential for that domestic violence to spill over into the workplace, that other workers within the workplace are protected. Now, we have developed a workplace health and safety guide for prevention of violence and harassment. And this guide provides a lot more information in plain language, and it also has a number of templates that can be used to help workplaces to establish some of the elements that we've just talked about earlier. Yeah. So how do you prepare your workplace? So first and foremost, you need to look and assess your workplace to determine the risk of workplace violence or harassment occurring. Then you have to go on and, based on that risk assessment, develop clear policy statements that express the employer's commitment to a workplace free of violence and harassment. Have to take measures to ensure everyone in the workplace understands what constitutes violence and what constitutes harassment. Have to develop procedures to assist everyone in recognizing and responding to violence and harassment. Have to establish reporting structures that allow workers to bring forward concerns without fear of intimidation or reprisal. And have to ensure the confidentiality of the parties when a report has been received. Personnel have to be trained in how to investigate reports of violence and harassment. And workplaces have to have clear direction on how to initiate an unbiased investigation of all reports. The purpose of investigations is to prevent incidents of violence or harassment occurring in the workplace. And if they have occurred, figuring out what went wrong and, tweaking the procedures that you've got to hopefully make sure that it doesn't happen again. And then once an investigation has been completed, there's a requirement to inform persons involved of the results of the investigation. And if other workers may be at risk, inform those workers of what was discovered during the course of the investigation. But it's also really important to maintain confidentiality as much as possible. So if others have to be advised, it's really how do you keep that to a minimum amount of information so that confidentiality isn't breached. And the other piece that has to be done is implement measures to prevent further incidents that are identified through the investigation. Now, I want to talk a little bit about what OHS's role is. So a large part of what we are going to do over the next few months is outreach to Yukon workplaces. We want to make sure that we inform all workplaces about the regulations. We want to really raise awareness about what constitutes violence and harassment in a workplace context, and provide information and guidelines on how to comply with the regulations. Now, once the regulations do come into force, We will continue with the outreach, but we'll also begin checking for compliance in workplaces. When we check for compliance, we want to verify that hazard assessments have been completed, that the risks have been properly identified, and that policies and procedures have been developed that address those risks. We want to make sure that people have put in place methods for investigating complaints. And we want to make sure that where we have found incidences where there isn't compliance with the regulations, that we issue appropriate direction through orders and other directions that will help the workplaces to get themselves into compliance. Some of the things that our legislation and regulation don't cover and don't provide for OHS to do is resolve or mediate specific allegations of harassment in the workplace. We can't do things like order individual remedies, such as monetary compensation to individuals who have experienced violence or harassment in the workplace. And we certainly don't interfere with reasonable management practices, which don't contravene the OHS Act and regulations. Now, when we do receive a complaint, this is sort of the process that we'll go through to try and resolve it or to understand what the complaint is about. First of all, there's an intake phase where we will gather information to help determine what actions are required by OH&S. In some instances, all that's really being sought from us is information and an understanding of how to proceed if there are concerns around violence and harassment, or if there are concerns that an employer doesn't have the appropriate things in place to prevent violence and harassment in the workplace. So in those instances, once we've spoken to the complainant, we've followed up with the workplace, we will simply provide information. And once that information is provided, we'll step back and allow the workplace to put the appropriate measures in place. But when we've gone through the sort of the intake phase, if we find that in fact there is something that we do need to look into, then we'll start our own investigation. And we'll do things like we'll contact the employer and we will inform them of the fact that we are looking into their prevention methods for preventing violence and harassment in the workplace. And we'll ask them to provide us with certain information. We will want to look at the policies, the procedures, the risk assessments pertaining to violence and harassment in the workplace, and get a feel for what they actually have in place. We'll look at how they go about their investigations. If we did receive a complaint and it was brought forward to the employer and the employer hadn't followed through on their procedures or had dismissed it out of hand, we will address those things as they occur. But once we've gone through that fact-finding process and we've got all the evidence that we think we need in order to sort of try and resolve it, we will then do a thorough review of all the information. And once we've done the review, if there's additional follow-up that we have to do, we'll follow up. We may need to do some additional interviews, those sorts of things, but we'll follow up. And if it becomes apparent that there was in fact a contravention of the Act and regulations, then what we'll do is we will issue orders. So when compliance isn't met, we will provide the workplace with a summary of what was reported to occupational health and safety. We'll summarize what evidence we looked at, what documents were provided, summary of any interviews, those kinds of things. And we'll very specifically talk about where we found there to be deficiencies within the processes and procedures that an employer has put in place. Once we've issued the orders for corrective measures to be taken, then our safety officers will monitor for compliance. They'll continuously follow up until we receive compliance with any orders that have been issued and make sure that that all of those orders have been fulfilled. And if it's determined that we're not getting to where we need to be with helping the employer get into compliance, then there's the possibility that we could use alternate means of getting compliance, things such as administrative penalties or prosecutions for failure to comply. Those types of things are all in our toolbox. That's very rare that we ever get to that point. In most instances, employers really are eager to comply, and in most instances, we find that they just aren't quite sure how to go about complying, and so we will help them through that process. If we do find that compliance was met, so when we do our investigation, we go through our fact finding, we make our determination that the employer actually does have a proper program in place, it is functioning appropriately, they have followed up on investigations and information and providing the employees with what they need, we will still issue a report. Now, the report won't contain any orders because there wasn't anything that the employer was out of compliance with. That summary report will do the same as in the non-compliance issue, in that it'll list the summary of the complaint, the documents that have been provided, a summary of the results of any interviews, and how we actually determined that the employer was in compliance. So that's sort of the process we'll go through, and then once we've issued those reports, we will close off that file. So what a workplace should be doing if they do receive a complaint is, if a report of harassment is received, assure the complainant that you do have a process in place and that process will be followed. An employer should ensure the confidentiality, but also ensure that appropriate internal reporting procedures are followed according to the written procedures that are in place. It's also important to explain the process to the complainant and what they can expect as an investigation proceeds. If required, they should take immediate measures to protect complainants or others in the workplace if it appears, that there may be something that is serious occurring. Don't wait for the results of an investigation. If there's something that needs to be dealt with immediately, an employer should take immediate action to try and resolve the issues. But you still need to go through the investigation process, and through that investigation, first of all, start by determining the appropriate person to conduct an investigation according to the written investigation procedures, then go through and investigate the incident or the complaint. Once that investigation is done, the investigator should produce a report, and once that report is produced, the employer should inform the person involved of the results of the investigation, inform other workers if through the investigation it's discovered that there may be risks to other employees in the workplace. But as I said earlier, maintain that confidentiality as much as possible. So if it is being communicated to other employees, make sure that just the minimum amount of information is disclosed so that they understand what measures have been put in place for their own protection of other workers. And implement any corrective measures coming out of an investigation. So that's sort of the, sums up at a very high level what the regulation is intended to accomplish, and what measures can be taken by employers and workers within a workplace. So we have already developed a workplace violence and harassment prevention guide. And if you want to see that guide, you can visit wcb.yk.ca. I'm not going to talk a lot about it because two of our safety management consultants, Chelsea LaRose and Shauna McLean, will be providing more information about this tomorrow. They'll go into some greater detail as to what's contained in the Workplace Violence and Harassment Prevention Guide. Probably go over some of the contents, some of the templates that are in there, and answer any questions that you might have more detailed and specific to that guide. So if you want any more information on violence and harassment prevention, our office can be contacted at 667-5450, or go to send email to worksafe@wcb.yk.ca. So thank you very much, and I look forward to answering any questions that people might have.
Hi, my name is Leo Lane. I'm a Crown Prosecutor based here in Whitehorse. I'd like to thank Director Dezan and the Yukon Human Rights Commission for inviting me to speak to you. What I plan to talk about is sexual offenses in the workplace, or the overlap between sexual harassment and the criminal law. But I have a couple of topics I want to go through before we get there. And so just to give you an outline, I'm going to start by explaining the role of a Crown Prosecutor. I then will outline how a criminal charge proceeds through the courts. And then finally, I will tell you about what I think are the sexual offenses most likely to arise in the workplace. A little bit about me. I'm from Red Deer, Alberta. I've been practicing criminal law for 12 years. I started out on the defense side in Vancouver with legal aid, and then I took a job as a Crown Prosecutor in Nunavut. I did that for 5 years before transferring here to the Yukon office in 2013. So the first topic, role of the prosecutor. We represent the Queen, or the Government of Canada. We prosecute all offenses found in the criminal code, so anything from theft up to murder. We prosecute all offenses in the Controlled Drugs and Substances Act, so illicit drugs. And we also do some work in regulatory or non-criminal charges under federal statutes like the Fisheries Act or the Elections Act, but primarily criminal law. And the purpose of a criminal prosecution is not to obtain a conviction, at least not in the Canadian system. Rather, it is to put before the judge or the jury what the Crown considers to be all of the relevant evidence that supports a finding that a person has committed a crime. And so a Crown Prosecutor must not act or even think in terms of wins and losses. Rather, our job is to fairly present all the evidence and act in the way that best serves the public interest. And so at the end of a trial, if I'm of the opinion that the Crown has proven its case beyond a reasonable doubt, then I will ask the judge or the jury to find the accused guilty. But equally important, if I do not believe that I've proven my case, if I think there's a reasonable doubt on the evidence, then I will ask the judge to find the person not guilty. So that's a brief overview of the role of a Crown Prosecutor. My second topic is how a case proceeds through the courts. So a criminal charge starts when the police become aware of it, either from direct observation by a police officer or because somebody has reported a crime. The police then go about gathering evidence, so interviewing witnesses, collecting physical evidence. If the crime is one that involves an identified victim, that's the stage at which the police will typically give the person the option to connect with victim services. And I believe you've either heard or are about to hear from Michelle Rabot, Supervisor at Victim Services, talking about the essential service that they provide to victims of crime to help them navigate the justice system. And we do some of that ourselves too. So at some point, the police will arrest the suspect. If there are public safety concerns, that arrest could happen quite quickly. Or if there's clear evidence of a crime, they could be arrested on the spot. Or the police might wait until the investigation is substantially complete before making an arrest. The police will take the person either directly to court in custody, or if the circumstances allow, they'll release them and just give them a court date. Then the police will lay a charge, which is essentially the officer taking a charging document called an information to court, swearing it in front of a judge or a justice of the peace, and that starts the proceeding in court. And the police will then forward all of the evidence that they've gathered to the Crown Prosecution Office. So any witness statements, officers' notes, things like that, we get everything. We review the charge to make sure that it's something that we can prove, that there's enough evidence to actually prove it beyond a reasonable doubt, and that it's in the public interest to prosecute. And if it's not both of those things, then we will withdraw the charge or enter a stay of proceedings, which is like essentially dropping the charge. If we are proceeding, then we will send all the material that we received from the police to the accused person or his or her lawyer. And that is part of the Crown's disclosure obligation, which is protected by the Charter of Rights and Freedoms and is an integral part of a fair trial. So everything we have as the Crown, the defense will get a copy of, subject to some very narrow exceptions. We will also meet with victims, often with somebody from Victim Services present. We'll explain the justice system, we'll hear from them how the crime affected them, and if the matter is heading to a trial, then we'll prepare them for how to testify at a trial. Meanwhile, as the charge is proceeding through the courts, the court will ask the person to enter a plea, either guilty or not guilty. If it's a guilty plea, then we proceed to a sentencing hearing, and the judge hears from both sides, the Crown and defense, and decides what the appropriate sentence is for that person on those facts. If the plea is not guilty, then we set it for trial, and the Crown has to prove the offense beyond a reasonable doubt. The trial proceeds by the Crown calling evidence first, and the defense has a choice at the end of that whether they want to call evidence or not. They don't have to, and oftentimes the defense will just argue that the Crown has failed to meet its burden. Once the judge, or again in some cases a jury, hears all the evidence, then they will render a verdict of guilty or not guilty. And if it's a guilty verdict, then we're back at the sentencing process that I just described. So that's a really quick overview of the criminal process, which brings me to my third and final topic, which is sexual offenses in the workplace. Not all sexual harassment, of course, is criminal in nature, but there are some forms of sexual harassment or some sexually harassing conduct that is so harmful or so morally blameworthy that our society has decided it must be considered criminal, and therefore it attracts all the stigma and consequences that come with that designation. Now, I've decided to focus on what I think are the 3 sexual offenses most likely to occur in the workplace, those being sexual assault, sexual interference, and indecent act. Sexual assault, sexual exploitation, and indecent act, which is sometimes commonly referred to as indecent exposure, but in the code it's called indecent act. And these are all found in the criminal code. I'll refer to them by section. So starting off with sexual assault, section 271. And in order to understand sexual assault, one has to figure out what the definition of assault is, common assault or non-sexual assault. And the code defines that as the intentional application of force to another person, which is the common one that we see charged. Somebody punches somebody or does something physical. Or what's lesser known is that an assault can be made out when there's simply an attempt or a threat to apply force to another person, if the person threatening force has the means to carry it out. And so from that definition of common assault or regular assault, then we can look at sexual assault. And the definition of sexual assault is an assault committed in circumstances of a sexual nature such that the sexual integrity of the victim is violated. So any act that violates the victim's sexual integrity can be a sexual assault. The offense covers a broad category of conduct. Sometimes it's overtly or obviously sexual in nature, and sometimes it's closer to the line, like a single touch or a kiss. And in those types of cases, the context has to be closely examined to determine whether it was sexual in nature or something else. Now, what you won't see in the definition is the concept of sexual gratification. And that's because the perpetrator's sexual gratification is not an essential element of the offense. It can be an aspect of the offense, but the Crown doesn't have to prove that the perpetrator was, say, turned on or received any pleasure from committing the offense in order for the offense to be proven. And so, as an example, an accused person who jokingly slaps a coworker's buttocks or grabs a coworker's breast, even where there's no evidence that the accused was sexually attracted to the victim or derived any pleasure from the assault, the focus at law is on the victim's integrity. And if that was violated, that's a crime. Another form of sexual assault where you may not see gratification at all is hazing activity in sports teams. So assaulting a team member in a sexually humiliating way. That would certainly interfere with the sexual integrity of the victim, and that would constitute a sexual assault in the criminal law. So that's sexual assault. Second is sexual exploitation, Section 153 of the Code. And what that says is that it's an offense for a person who's in a position of trust or authority towards a young person to touch the young person for a sexual purpose, or simply invite or counsel the young person to engage in sexual touching. So the first one being actual physical contact, the second one being communication of some kind, where the perpetrator is inviting future sexual touching or trying to get the young person to engage in sexual touching, even where no actual contact has occurred. And for this offense, young person is defined as somebody who's either 16 or 17 years old. Now, for sexual touching, it might seem odd at first that there would be a separate offense for this, sexual exploitation, because of course any non-consensual sexual touching is also a sexual assault. And the reason that we have a separate offense, the difference between these two offenses, is that for sexual exploitation, consent is not a defense. So for sexual assault, consent is a defense. If the other person has agreed to engage in sexual touching, of course, there's no crime. But for this case, the consent is not a defense to sexual exploitation. And so the so-called consent of a 16 or 17-year-old to engage in sexual touching or sexual communication with a person in authority is simply not recognized at law. It's not a defense. And so what the effect of this offense is it raises the age of consent. So in any other case where we're talking about a sexual contact between an adult and a younger person, if the young person is under the age of 16, the law doesn't recognize their consent. It's simply not a factor. Whether the underage person is a willing participant or not does not excuse the conduct of the older person who should not be engaging in this situation. So the age of consent is under 16, or is 16 and above, sorry. But what this offense does is it creates a second category where the age of consent is raised for some types of relationships from 16 to 18, and that's where the perpetrator is an authority figure. And so just as any sexual contact between an adult and a person under 16 is automatically criminal, with or without so-called consent, if an adult has sexual contact with a person under the age of 18, but 16 or up, so 16 or 17, if the young person is somebody under their authority, that as well is automatically criminal. And so what do I mean by a person in a position of authority? It could be, for instance, a store manager. So a store manager has a teenage employee. It's a crime for the manager to have any sexual contact or sexual communication, that can include text messages, social media, if the purpose of the sexual communication is to invite future sexual contact. It's a crime for the manager to engage in any of that kind of behavior with their young employee. The law does not recognize or does not excuse the older person's conduct if the younger person is said to be consenting, and that's because of the power imbalance inherent in that relationship. And so in a relationship of trust or authority, sexual contact or communication is seen as inherently exploitative and morally blameworthy. So I mentioned store manager. Other positions of trust or authority could be a teacher. So a teacher can't engage in this kind of behavior with a 16 or 17-year-old who's under their control. Position of trust could be a close relative, so an uncle or a longtime family friend if there's a trust relationship built up there. Position of authority or trust, camp counselor, hockey coach, any number of positions like this where young persons are protected. And so the purpose of the law is to protect the sexual integrity of the young person from exploitation. So that's sexual exploitation. The last offense is indecent act, section 173 of the code, commonly referred to as indecent exposure. And there are two ways that this crime can be committed, one in public and one in either public or private, any place. So the first one in public is a crime to willfully or intentionally do an indecent act in a public place in the presence of one or more people. And so that would be the most common type of this offense, or the most common iteration, where you have somebody who exposes themselves or masturbates in a public park. So willfully doing an indecent act in a public place, that's indecent act. The second type is the one that I think is more likely to come up in an employment context, where such acts are typically done in private spaces than in public spaces. And the second type of indecent act is where a person intentionally does the indecent act in any place, public or private, with intent to insult or offend another person. And so why I say that this may come up in employment context is that we have actual firsthand accounts in recent years coming out through the Me Too movement of people in the workplace or in work-related meetings exposing themselves to coworkers or potential coworkers. And I'm thinking of the two highest profile ones, examples of this: Harvey Weinstein, setting up a meeting with an actress or somebody in the entertainment business, and it turns out that the meeting's in a hotel room, and he exposes himself to the other person. Or Louis C.K. is the other one that was in the media. There were various accounts of him exposing himself to colleagues, other junior comedians, I believe. And so the Crown, to prove an offense in those situations, would have to prove that the conduct was willful, i.e. intentional. So the Crown has to prove that the accused knew that they were being watched. It is not a crime if it's unintentional, and I'm thinking here specifically of the recent case where a journalist was in a Zoom meeting, thought that his video was turned off, and exposed himself. That, however harmful and morally suspect and unhealthy for the workplace, was not a crime, because there was no evidence that the individual was doing it intentionally. And so it's not criminal conduct. So that's the first part. The Crown has to prove intentionality. And second, the Crown has to prove that it was done with a particular motivation, and that's to insult or offend. And this is more difficult to prove because the Crown is asked to show evidence of the perpetrator's state of mind. But where you've got a boss or a supervisor of some kind doing this to somebody who they have authority over, or even colleagues, co-workers on the same level, I would argue that there are certainly cases where the point of this conduct, of exposing themselves, is to exert dominance over the person, and the perpetrator is deriving some form of pleasure from subjecting the other person to this. And so the intent to, may not be the intent to insult, but the intent to offend. The intent is to show the other person something that's offensive. and so the crime would be arguably made out on those facts. So those are the 3 sexual offenses that can arise in the workplace, or most likely to arise in the workplace. And just in closing, I will say, if you are the victim of a sexual offense in the workplace, or if you have witnessed what you think might be sexual offending in the workplace, I urge you, please call the RCMP. We, in my line of work, regularly hear from victims about the long-lasting and devastating effects of sexual offenses in the workplace and in people's private lives. And victims can experience increased stress, loss of trust, diminished self-worth. They can blame themselves, and it can profoundly limit the victim's ability to find fulfillment or advance in their chosen line of work. We also hear from victims how hard it is to come forward and report their coworkers or report their supervisor for this kind of conduct. Victims worry that it may cost them their job, may cost them friendships at work. They oftentimes worry that they won't be believed, or that people will blame them for what happens to the perpetrator that they're reporting on. And there's also an inherent inequality in these types of offenses, because the perpetrators are more likely to be men, not always, but more likely to be men. The victims are more likely to be women. And so it adds to the systemic barriers that women already face in the workplace. And so if we want a society where everyone has an equal opportunity in the workforce, we all have a responsibility to prevent sexual harassment from happening in the first place, or to expose it and bring it to an end when it does occur. So thank you for your time and attention.
Hi, I'm Michelle Rabeau, and I'm the supervisor at Victim Services. Victim Services is a service of Yukon government. We work with victims of all crime, no matter when the crime happened, whether or not the person's been to the police, and any age or gender of somebody that comes to our door. So this would include people that come identifying as a victim of harassment or sexual harassment in their workplace. We have 3 offices in the Yukon. So we have one here in Whitehorse, which is 301 Jarvis. We have an office in Dawson with 1 worker, and we have an office in Watson Lake, who has 1 to 2 workers, depending on where we are with hiring. We also provide service to every single Yukon community, as well as Atlin, Good Hope Lake, and Lower Post. So we have a worker assigned to each community. We travel during court, and we travel during off court as well, and have somebody everywhere. We are a consent-based service. So that means we only see people who want to come here or want to access our services. People can't be mandated to victim services. We're also a confidential service. So that means people can come here and expect their privacy maintained and their confidentiality maintained. We don't share information without somebody's consent. And people need to know that when they come here. It's a pretty important value of our service here. There isn't a formal referral process for victim services. Anybody can refer somebody here and ask us to call somebody who's identifying as a victim. All you need to do is get consent from that person to share their number. People can also call us themselves. They can come in, they can text our workers, they can email us. The services we provide here at Victim Services are crisis support. So we have lots of people coming here in crisis after a crime, after being sexually harassed. Somebody in their family or a friend has experienced a crime and they're not sure what to do. We can give information, we can talk about options, we can lay out the possible scenario if you're going to go to the police. If you've gone to the police, we can talk about the court process. So we're here to give information, not advice, but information. When people come here disclosing sexual harassment, we will do the same thing as we do with anybody that comes in. We will listen to them. We'll talk about what the options are for perhaps reporting, for not reporting, for documentation, finding supports in their life, and different places to go. We would provide service to somebody who has noticed somebody being sexually harassed as well. They could come in and say they're just not sure what to do. They're not sure how to help their coworker or their friend. And we would talk with them about some options for that as well. We provide court support. So we have a worker in every single court hearing pretty much in the Yukon, and we just to follow what's going on. So we have victims here whose perpetrator has been charged. We'll go to court, we'll call them after and let them know what's happened so they don't have to go. So in cases of sexual harassment, if the same thing has happened, if somebody has been charged with a sexual offense and it's going to be in the court system, we have workers that can go and we can follow up with the person who's named as the victim and tell them what's happened. So that's an easy way for victims of sexual harassment to find out and to know what's going on in their case. We also do accompaniment. So we go to appointments at the Crown. We bring people to RCMP. Maybe they want to make a statement. Maybe they want to add to their statement. Maybe they want to talk about options for them. We do advocacy. So victims will come to us and say they're not getting this service or they need help accessing a service, and we will work with them to try to get them what they need. We navigate with people through the justice systems and help them find where they need to go to get the information they need. So that might be going to the police or going to the coroner or going to the Crown. We have supported people who have been through the human rights process after disclosing sexual harassment in their workplace. So we have gone to hearings with people. We sat outside the hearing as a support with them and been here as a support after as well. So that's something our office can do. We also support people with protective orders, and we do so in two different ways. One, we're designates under something called the Family Violence Prevention Act, and that's a territorial act and makes us designates to help people get something called an emergency intervention order, which is a short-term order that provides somebody sole occupancy of a house or provides somebody with no contact conditions with the person who's causing them harm. People can come to our office and we can do that with them. And if it's applicable, have it within about a day. We also help people get peace bonds, and that is a order through the court where we bring people to a court hearing, they present their evidence to a judge or a JP, and they can get a similar thing. It's a no contact order with the person that they are alleging causing them harm. That might be something applicable in sexual harassment or harassment in the workplace. If they're seeking a no contact with the person, that would be a complicated thing to do, but it's certainly something that we can help somebody with. We have practical supports here. So we have a Victims of Crime Emergency Fund, which helps people with emergency expenses after a crime. Like if a door was kicked in, we could help replace your door, your glasses were stolen, or your medication was taken. We can help with those kind of emergency expenses. And we have a cell phone program. So we give out cell phones, they're flip phones, and we give them out to people that need to have them for safety in the community. Some other programs we run here are Project Links, which is a multidisciplinary project for child victims and witnesses. And that is a wraparound support. So there's no wrong door for kids or young people to go to. And we partner with the Crown, with the RCMP, and with court services, and sometimes family and children's services. We have a project called SART, which is the Sexual Assault Response Team. So we coordinate the victim supports through our office in coordination with the hospital who coordinates their medical resources there. People on the SART team are RCMP, so they're specially trained officers that can respond to sexualized violence. There's a crisis line that's run out of an NGO in town that can take calls 24 hours a day. And we have workers that can attend at hospital or RCMP during the day or weekend nights, so Friday, Saturday, Sunday nights. Through SART and through our training with sexual assault, we also have something called third-party reporting, which I think is probably relevant to victims of sexual harassment. That's a way you can report to the police the being sexually assaulted or harassed anonymously. So somebody could come here, or they could go to Keoshi's, and they fill out a form which describes what's happened. That form is sealed without their name on it, and the information is given to the police as an information file. Their name and contact information is kept sealed at Keoshi's, And if police want to reach the victim, they would call Coyotes to do so. So it's an anonymous way to report your crime. Some people just want the police to know what's happened. Some people don't want to go forward now, but want the evidence on record in case they decide to go forward later. So that's an option that we have here that we can help people with. We also offer a program called Independent Legal Advice at Victim Services, or ILA. Independent Legal Advice is a project where people can come and get 4 free hours of independent legal advice with a roster of lawyers. So we have lawyers that specialize in criminal law, in family law, in civil law, and people can meet with that lawyer for 2 hours and then meet with another lawyer, the same lawyer, for 2 more hours if they want. And through this project, they can get, as I said, advice and client solicitor privilege. So it's a totally confidential way to discuss what is happening to see what your best legal options are. I think that would be really applicable to some victims of sexual harassment in the workplace. And certainly is something that we've supported people with in the past. As I've talked about some of the partners we work with in different projects that we have. So we work with the RCMP a lot. We work with the public prosecution a lot. And I think there's going to be a presentation by the public prosecution in this series of talks. So we work with them when there has been charges and there's going to be a prosecution. We'll help PPSC meet with victims. We'll pass on information from victims. Sometimes victims want to be involved in the process and sometimes victims don't want to be involved in the process, and we'll support them either way. So we work with the public prosecution in that way. We're connected to Yukon Community Corrections. We're connected to the lawyers from the Independent Legal Advice Project. I think we have 6 of them on the roster right now. We connect with Family and Children's Services, the Human Rights Commission, Coyotes. We're well connected throughout the community of Whitehorse and throughout the Yukon. I think that's all. We do a lot of things here, but I think that's kind of relevant to the topic at hand. And what I would say is just call us if you have any questions, and we are always happy to talk about if we're a relevant service. Our phone number in town is 667-8500. And you can reach out at any time, well, Monday to Friday, and you can ask for me, Michelle Rabeau. You can ask for a victim services worker, and we can help you in any way we can. Thanks for letting me talk at this conference.
I'm Alexander Dezan, legal counsel at the Yukon Human Rights Commission. If you've been watching for the last hour, you saw my presentation. So we're going to go around, introduce ourselves, and then start with a question from the viewers.
Okay. I'm Kurt Diekman. I'm the president CEO of the Yukon Workers' Compensation Health and Safety Board.
I'm Michelle Rabeau. I'm the supervisor of victim services.
And I'm Lauren White. I'm a Crown Prosecutor with the Public Prosecution Service of Canada.
Great. Thanks very much. Nice to be here with you all on this panel, though virtual. It's still nice to sort of connect virtually. Now, Kurt, I believe the first question is to you. And I also believe you have already answered it in silence. So you've had a dry run on this. So go ahead.
Okay. Thanks very much. Yeah. So training. There is training in workplace investigations currently offered through the Northern Safety Network, Yukon. The training that they've got is around how to investigate, sort of generically, how to investigate any workplace incidents or fatalities, serious issues that arise, but it isn't really specific to how to investigate where there are allegations of violence or harassment in the workplace. So over the next little while, we will be working with Northern Safety Network to see if we can develop some modules that would specifically address issues around violence and harassment and tailor that training a little bit so that people understand, issues of confidentiality, issues of sensitivities that may be experienced when dealing with these types of investigations.
That's interesting. If I can jump in and just add one thing. I mean, so internally for the Yukon Human Rights Commission, we do investigations as well that pertain to the specifics of our process, which is going to be a little bit different from lots of other things. But I'm also aware that there are institutions out there who offer investigation courses, some of which staff here have taken. They're often quite general. I think a similar thing, Kurt, they wouldn't necessarily be tailored to, in your case, harassment and violence, in our case, anything pertaining to discrimination or harassment. But that said, they certainly do outline some principles and helpful tips, especially if you have individuals who've never really sort of questioned a witness, sort of brought out stories or things like that. So there are institutions out there that offer those kind of courses more generally, but it sounds like what Kurt's describing, getting some modules up specifically for these issues, would be super helpful moving forward for sure.
Yeah.
So that answers the first question. I believe the second question that we have before us here is aimed at you, Lauren. So if you wouldn't mind grabbing that one.
I don't think I can answer it just myself, but the question is, can workplace investigations happen concurrently as RCMP/Crown Prosecutor investigations? From the Crown's perspective, I mean, it would really be up to the RCMP, obviously, as they do the investigations, not the Crown. But I wouldn't see a problem with it from the Crown's perspective. I'm not sure if there would be an problem with it from a workplace investigation perspective. I'm not sure if Kurt can answer that.
Yeah, so it wouldn't be a problem from our perspective because we would be looking at very different things than what the RCMP would be looking at. So where the RCMP may be looking at the criminality and whether or not something criminal happened within a workplace and would be dealing very specifically with the issue of an assault or a sexual assault or a violent act within a workplace. What we would be looking at would be whether or not the employer has complied with the requirements under the regulation. So our regulations require people or workplaces to specifically have policies and procedures in place for dealing with issues where they're reported internally. And so we would look to see, do they have those policies in place? Do they have those procedures? Are they following them appropriately? Are the workers aware? Have they been properly trained in how to do the reporting? All those things is what we would be looking at. We wouldn't be looking at sort of the criminal aspects of an assault or an alleged assault within a workplace.
All right, so the third question actually we have directed to you again, Kurt, regarding investigations.
So there again, like if we had a report of sexual harassment, we wouldn't be investigating the sexual harassment itself and the criminality. What we'd be looking at, as I said, is the compliance with the legislation. And we don't require the person who was allegedly harassed to even report it to us or to be involved in that investigation if they don't want to be. But once we start that investigation, we will see it through to the conclusion because it is about the processes, policies, procedures that the employer has to prevent it from happening again. So it doesn't, so if we come in and we find that they don't have those things in place, even if there wasn't, if nothing had happened, if we go and do a regular workplace inspection, we ask to see their policies, their procedures, how they deal with violence and harassment within the workplace, we will investigate. If they don't have anything in place, we will follow that through to the end, issue orders, make sure that they do fulfill those requirements. So we would continue to do the investigation and continue to examine whether or not they are meeting the requirements of the legislation that they're required to meet.
Okay. I know that was directed at you, but I would maybe add again, sort of to juxtapose the commission's process. So for example, if we were at a point where a complaint had been accepted, a complaint regarding workplace sexual harassment, and we were at the investigation phase, that's still within the period of our process where someone can withdraw their complaint. So for example, if we've begun the investigation and that work is underway, and for whatever reason the complainant has decided I would just rather not proceed any further, actually are able to do so at that point. They would simply communicate that to us, and we'd probably have a conversation with them first just to give them as much information as possible about what that might mean. But that is something that someone in our process at the very least could do. Okay, we have a question now for everyone. The question here is, oftentimes we hear from tradeswomen who are experiencing workplace harassment that there are no avenues of redress through their workplace. So the question is, to what process should they be referred? So, Michelle, I see you've unmuted yourself. Do you want to go ahead and take that first?
I was unmuting in case you're going to ask me. She hasn't talked yet. It has definitely, we get those calls here, and it's a hard thing to answer. I think we refer to the Human Rights Commission. We refer to the police if that's applicable. Sometimes we talk about protection orders if that's applicable. So I mean, it depends on what's going on. I don't know what easy process there is, and we acknowledge the reality that if you're I don't know, if you're in mining camps there, there's a lot of workplaces where coming forward might not work out in the way of you keeping your job and being happy in your job. So we really try to acknowledge the complexity of what people are going through, but I don't know what clear cut, like do this and this and this to have that issue addressed. But I think that's where we would start.
Can I weigh in from our perspective? So I would recommend that people do contact us. We don't have an ability under our legislation to offer remedies for the worker. So, you know, if there was, as far, and when I say remedies, I mean like monetary compensation or, reinstatement, those kinds of things, that we don't have those abilities. What we would do is enforce our legislation, and we don't need to identify who the complainant is in order for us to do an investigation. So if somebody wants to remain anonymous and tells us, wanted to let us know, for example, that there were no policies or procedures in place, there was no place they could turn into in the workplace in order to bring that complaint forward, or if they had brought a complaint forward, there was nothing done about it, they can advise us, and we will go in and make a determination as to whether or not the policies and procedures are in place and being followed. And if they're not, we will issue orders. We will, if there's a failure to comply, we can prosecute for failure to comply with the requirements under the Act. We can issue administrative penalties. There are a number of things we can do there, but there is no redress as far as being able to offer compensation for a person if they have been harassed under our legislation. That would have to fall to probably the Human Rights Commission, I would imagine, or some other avenue there.
And I would jump in there and just sort of say this circumstance as described is certainly something we would encourage someone to call us about. As I mentioned in my presentation, typically how our process starts is from something like that happening, giving us a phone call or coming by, just have a conversation about it so they're aware of our process and what it might mean. Michelle, you raise a good point. It's sometimes difficult to engage in a process, file a complaint, start something when you're still actively employed somewhere and want to keep that job. That's difficult, and that's a difficult decision to make. From our perspective, we just like to tell people, equip yourself with the knowledge and feel free to give us a call, and we can, a big part of what we do is responding to those types of inquiries and just providing people information about our process and say, this is what this looks like. So I would certainly encourage people in such a circumstance to at least give us a call so that they have a bit of information about how they may want to proceed and if that avenue involves us or not. Yeah. So we have received another question, this one to myself, Kurt, and Lauren. Question is, can you speak to the difference in the definitions of harassment and the implications of that and those differences? I'm wondering perhaps if, Lauren, you might start discussing what that might mean in the criminal context, and then perhaps Kurt and I can discuss how that may differ in our processes.
Right, and I might be a bit repetitive in terms of Leo's presentation. He gave me the notes of what he spoke about, so I'm familiar with it. So, and hopefully he brought this out in his presentation. There's no such criminal offense in Canada, at least, as criminal harassment per se. What there are different criminal code offenses that could involve sexual harassment. So the ones that Leo highlighted, and I would say probably the more common one would be sexual assault, sexual exploitation, and indecent act. So it's, I suppose, an unfortunate reality that someone might be harassed in the workplace, but that harassment, particularly if it's just verbal in nature, that wouldn't constitute a criminal code offense. That's not something the RCMP would investigate or our office would prosecute. So I suppose the implication of those more narrow definitions for criminal offenses are that some harassment in the workplace might not fall into those categories. That said, the flip side is that obviously criminal offenses are very serious. There's a lot of stigma attached to them. There's quite dire consequences, including jail. So that's why those definitions are a little more narrow when you enter the criminal realm. So I obviously can only speak to what criminal offenses might apply. The broader definition of harassment I would leave to the other panelists because they would know more than I would about that.
Sure, and I don't mind jumping in there to discuss at least the definitions under our Act. So it's kind of defined, harassment is defined in our Act as a course of vexatious or unwanted conduct that one reasonably ought to know is unwelcome. It's kind of a lot to unpack there. So one is mainly just, it's generally a course of conduct. It isn't exclusively such. Serious one-time incidents can amount to harassment, certainly. It typically does realize itself in a course. Vexatious or unwanted conduct that one ought reasonably know. So it isn't so much, it isn't, discrimination and harassment intent actually isn't a concern. Whether or not someone intended to cause harm, whether or not someone intended to harass is not actually at issue. What's at issue is whether or not they should have known that it would be harassing. And that is kind of an interesting concept. So that's a concept that has sort of changed over time. Case law has sort of changed what that may or may not mean. But ultimately, if a reasonable person would believe that to be harassing behavior, then that could amount to harassment. But for the purposes of our Act, which is something that probably distinguishes itself a bit from occupational health and safety legislation, for example, is that any harassment or discrimination must be tied to one of the protected grounds protected under our Act. So when we talk about workplace sexual harassment, it must be related to one of the three grounds to which apply to that, which are sex, which includes pregnancy, gender identity or gender expression, or sexual orientation. So if the course of conduct involves harassment or discrimination on the basis of one of those three protected grounds, it could conceivably meet our definition for the purposes of accepting a complaint, and ultimately moving through our process, perhaps even all the way to a hearing. So that's generally what it means under our Act.
Okay, thanks. And yeah, I'll weigh in now. So the ought to have known, that piece of it all is the same as ours, but our definition is actually broader than what the Human Rights Commission definition is. Our definition means bullying or any other objectionable conduct or inappropriate comment by a person that occurs in a workplace or is work-related, that the person knows or ought reasonably to know is likely to be unwelcome, and that adversely affects the worker's physical or psychological well-being or constitute a threat to the worker's health or safety. So if they ought to have known, it isn't tied necessarily to the prohibited grounds, but it includes prohibited grounds that would be found under the Human Rights Act. And it is broad enough that it can also relate to a single incident. So it doesn't have to be a course of vexatious conduct. It can be a single occurrence of vexatious conduct that somebody ought to know would be offensive. And at that point, and the reason for that is because the responsibility for ensuring the safety in the workplace lies with the workplace parties. So the employer has an obligation to ensure that that workplace remains safe. And so if there are any conduct that occurs in the workplace that could be offensive to others in the workplace, the employer has an obligation to step in and prevent it at that point. So we are not investigating the same way that the Human Rights Commission would investigate to determine whether or not it actually there was an incident that occurred. It was at a level that could require some sort of redress or compensation or charges or those kinds of things. What we're looking at very explicitly is, does the employer have things in place to prevent this from happening? And if they don't have something in place to address the single occurrence or the continuing conduct, then we are holding the employer accountable for not providing adequate protections for their workers in the workplace. So ours is a fairly broad definition and can incorporate quite a bit.
Great, thanks everyone. For the next question is directed to you, Michelle, if you don't mind jumping in and handling that one.
What supports are available to people in rural Yukon? From my service, we have an office in Dawson, we have an office in Watson, and we travel itinerantly to every Yukon community, including Atlin, Good Hope Lake, and Lower Post, which aren't Yukon communities, but we travel there too. We follow court, but can go to any community when asked. So, but we're not in any community at any given time. So if we're not available, we're talking to somebody, we also refer to mental wellness and substance abuse. So they have counselors that travel or live in most communities in the Yukon as well. And we work closely with them. So in terms of responding to what one would do if they were being sexually harassed at their workplace, I don't know exactly how mental wellness would jump in, but in terms of giving emotional support and helping people figure out what their next steps are, that would be a referral we would give. We work with First Nations as well. We work with justice departments in First Nations. So that might be somewhere we would connect people as well. And most First Nations have a justice or a health department, and they have workers through that. But it's definitely a gap. And I think all of us are aware of that. It's harder to get service sometimes in the communities than it is in Whitehorse, for sure.
Thanks, Michelle. The next one is directed to me and to Kurt. I'll read it aloud. When harassment is virtual or online, say through an inter-office messaging system or through social media, are there any processes in place to support those victims and help identify the harasser when they try to hide their identity? That is an interesting question. Kurt, do you have any initial thoughts on that one?
That is, yeah, I would actually have to defer to our IT folks on that to know if there was a way to actually figure that out. But bottom line, from our perspective, when processes are developed, so when the policies are developed and the processes are developed, first thing that has to happen is that an employer has to look at the potential hazards of the workplace and the risks of those hazards occurring. So they have to look and see, if there is a potential for harassment through online messaging, inter-office, online stuff, they would have to look and see if there are ways to deal with it. Sometimes, you know, if people are able to mask their identity, et cetera, it could be very hard to identify the harasser, but there is an ability to put things in place in your workplace to prevent some of that messaging coming in, or some of those things coming in, if you can identify, you know, that it could potentially be an issue. So depending on the sophistication and the abilities of the organization, they, you know, an organization that has a large dependence on IT has IT folks in place that deal with it. You know, for example, Yukon government or a large employer, there would be far greater expectation on them than there would be on, say, a mom and pop operation running a convenience store. So it's a difficult issue to deal. It is a difficult issue that we have to deal with. So I don't know if that offers in a good answer, but
I think that's helpful. And frankly, I think a little bit more than I would be able to say on it. I know it was directed at me as well. I mean, if the question is, are there any processes in place specific to support that type of victim? I mean, as I mentioned in my presentation, we're a complaints-based process. We unfortunately don't have a general mandate to sort of monitor workplaces or those types of things. So if something's coming in through inter-office messaging, I mean, I would hope that the organization in question would have the ability to at least identify the parties and also perhaps stop that chat function if there was a complaint on that basis. Regarding whether or not if it's coming just sort of generally through social media, I mean, again, the commission certainly doesn't have the ability to go out and sort of monitor those types of things. And you know, as we see from the news, it's, you know, that type of behavior sometimes can escalate very severely and into the criminal realm. But in terms of specific processes, there's nothing unique to the commission that offers a specific support for that particular set of facts, let's say. So we have another question. This one's directed to everyone. Question is, what tips or resources would you recommend for managers responding to reports of sexual harassment in the workplace? Oh, pardon me, I was supposed to ignore that one, but I think we should probably still answer it because I think it's a pretty good question. Does anyone want to jump in and give those tips?
Well, I'd say that there are, you know, there are some things that managers should be doing if they're responding to reports. One is right up front, advising the person who's making the report of any resources that are available to them. You know, if you've got an EAP program, you know, directing them to victim services, to you know, whatever resources there are available in the territory that could help them once they receive the report. The other thing that they should be doing is when they receive a report, assure the person, making sure that they're assuring the person that they've got policies, procedures in place, that they will be following those policies, those procedures that they've got. They will be doing the investigation and seeing this through. They should never just out of hand discount a report. It has to be taken seriously. We've developed a workplace violence and harassment prevention guideline to help employers develop the programming that they need. When they develop that programming, they should very specifically have sort of tips for managers in how to respond when they do get a complaint, and they should be. It should be also be accompanied by specific training in their own policies and procedures to make sure that managers know who the appropriate people to report are, where to direct the workers. So the employer is responsible for developing a lot of that material, but we've also got a lot of material identified in our guide. And I know that, Human Rights Commission also has some really good resources available that they can identify as the victim services. So those are places that I would recommend that managers go to get additional information.
And I think once somebody comes here, what I talk to managers about is that, I understand managers need to have a neutrality when they're taking in complaints sometimes because it might be about other employers, but that doesn't, or employees, sorry, but that doesn't mean you can't be supportive. And I don't think neutrality and support are opposite to each other. I'd also as much control as managers can give their employee. I know I have worked with lots of people here who felt the process once they went to a manager was completely taken out of their hands. And this might speak to the next question you're going to ask, but calls to the RCMP were made without the employee's consent, citing policy, that our policy is when we hear about this, we need to go to the RCMP. So when you're talking about workplace policy, I think that should give managers some control over how they're working with people and listening to people and doing what they want and need. We know with sexual assault and sexual harassment that often your control is taken away from you. So here we try to give people as much control and processes as we can. So I like the idea of giving information, and these are options for you, but letting people decide what that is.
Yeah, that's great. I would echo some of that. I mean, having good policies and practices in place can help deal with reports of workplace sexual harassment sort of more efficiently. They can also lead to a culture of prevention, knowing that those things are in place and utilized fairly when situations arise. But I would say just try to be as sensitive as possible to the victim. I mean, it's very difficult to report these types of things. It can be extremely difficult on the individual who is, especially again, in workplaces, sometimes these are things that have been going on for months or years. Do your best to keep things confidential and be sensitive to the parties involved so that, I mean, if you have a policy or practice in place that you want to investigate and sort of get to the bottom of it, so to speak, that's one thing, but that doesn't necessarily mean you have to disregard what the parties are going through, particularly the person reporting. So I would echo that. So we have another one here also sort of to everyone. If an employee advised their employer of sexual harassment in the workplace, would it be appropriate to advise them of their option to also pursue, in addition to a workplace investigation by the employer, something like a human rights complaint or filing a claim with the RCMP? So would it be appropriate to advise about other processes? From my perspective, I don't mind jumping in first. Yes, that would be appropriate. In certain circumstances, we have a unique provision in our Act that requires people to exhaust reasonably available procedures. Those are sometimes provided under another Act. Those are sometimes provided for in something like a collective agreement. So for example, if someone is unionized and has a grievance procedure that they can follow, those grievance procedures often have, steps 1, 2, and 3 of the grievance. They also typically are followed in many circumstances by an arbitration to either some type of arbitrator or labor board. Where such a process exists, our Act requires that they go through it, in part because labor arbitrators, at least in the grievance context, can apply human rights remedies. So they actually can award human rights damages. Now that said, maybe you don't have that process, but your employer still wants to look into it. That is fine. You can still come to us and talk to us. You can still file a complaint with us. Anyone is free to do so within 18 months of the alleged contravention. So you have a year and a half in order to decide when to file. We always encourage people, if they're going through something at work, to reach out to us, and we can provide information, and that may involve going through 2 processes at once. I'm not sure if anyone else had anyone to add on that one. No? Okay. So it seems we are up to our final question. Kurt, this one's aimed to you. If you wanna read it aloud, please.
New OHS legislation in Yukon, are there any provisions for mandating the confidentiality of the complainant? I'm thinking especially about someone making a complaint in one of the communities where it's very small and interconnected. So with the way we handle a complaint under our legislation and under the new regulations that have come into place, we would maintain confidentiality right up until we are, legally have to make a disclosure. So if somebody wants us to maintain confidentiality, we will keep anything that is said to us confidential. The results of any investigation would be written in such a way as to protect the identity of somebody if they wanted to be protected. But if there was a requirement, like if we were laying charges and it was going to be taken to court and there was a requirement to disclose, that would be, the only time that would happen. In those instances, though, we do, take into account, before we would do a prosecution, we would take into account the desires of the person who had done the reporting. If there was, in fact, a sexual assault or violence or harassment perpetrated against the person, we would speak with Crown to make sure that, we were all on the same page and we were doing, we were maintaining confidentiality, and we could also deal with it, like, rather than laying charges in instances where an employer hasn't appropriately put things in place. We can deal with it through administrative penalties as well, and in those cases we would not necessarily have to identify a person who had been assaulted, because the reality of it is what we would be laying charges for, or what we would be issuing administrative penalties for, or writing orders on, is whether or not policies and processes were in place, and whether or not those policies and processes had been followed, which doesn't necessarily require us to identify any individual. Right? So, but that is a very tough one in all circumstances. And just to speak a little bit, and it sort of ties into the last question as well, in that, when you are in small communities and when a supervisor is advised, they should always be telling the complainant about other areas where they can go, what other resources are available and what other options they have for dealing with the complaint. Because the last thing that you want is for an employer to try and discourage somebody from reporting if they want to report it outside of the employer confines.
Great. I believe we are out of time, unfortunately, but that was a great discussion. Thanks everyone out there for those contributions. Those questions were great. Yeah. We really appreciate your attention, and that was great. Thanks very much.
Thank you.
Thank you.
Thanks, Alex.
Bye.